Hello and welcome to Radio Pete's Wealth Talk. My name is Pete Williams, the host of the program on which we talk about all things wealth, from wealth creation, wealth preservation, and ultimately wealth distribution. And it is that last subject matter that I want to introduce today, and that is the subject of estate planning, handling our affairs should we become deceased or incapacitated. And the first thing I want to make clear is that there's really two aspects of estate planning. There's planning for our financial estate, and then there's planning for the person and healthcare. In both cases, what we're talking about is creating documents that handle our affairs when we're unable to do so by reason of death or incapacity. In the case of financial matters, it's all about bank accounts and investment accounts and real estate and that sort of thing. When it comes to the person, it's whenever we are unable to make choices for ourselves as to healthcare, where we live, what medications to take, and decisions as to what happens to our person. I'm not going to talk about that today. I'm going to be talking about financial estate planning. We will discuss estate planning for the person at a later time. I have a definition here that I have been using for a very long time now. I sort of like this definition of estate planning, which I will just read to you here real quick. Estate planning is the process of creating and implementing a set of legal and financial instruments in order to ensure that your assets are handled and ultimately distributed according to your desires in the event that you should be unable to do so by reason of incapacity or death. But just to highlight these things that I've noted here in yellow, it's important to create an estate plan, but it is also important to implement the plan. There's certain things you do, such as creating a trust, and it's not just good enough to create a trust in estate planning. You also have to fund the trust, change title to accounts, and that sort of thing. Secondly, estate planning involves both legal and financial instruments. So there's documents that are created by the attorney, and then also there's documents such as beneficiary designations on IRAs and 401ks and so forth, annuities, and life insurance. Estate planning also pertains to handling and ultimately distributing. It's important to know that you have control of your assets. The way assets are handled, you can make judgments on, and then to whom they're ultimately distributed. These are in accordance to your desires. I've been practicing for many years now, and including in my law practice, as well as my fiduciary practice now, where I act as trustee to trusts. I come across cases sometimes where there are influencers who want to influence how an estate plan is written. And it's very important to know that you can leave your assets to whomever and however you wish, and other people may have other desires, but it's important for you to get into a room alone with your attorney to make your desires known. And finally, the point of death or incapacity. I think a lot of people think of estate planning as creating documents for when I die. And whereas while that's true, it is also just important to plan for incapacity, because a long-term incapacity actually even be worse from a financial standpoint. And the point is that whenever you are unable to handle your own affairs, you cannot write your name, you cannot create a contract, you can't sell property, you can't buy property. That's when your estate planning documents spring to life, is when there is an incapacity. So it's very important to plan for that. Secondly, I want to point out what I consider the goals of estate planning to be, and that is to be both effective and efficient. What we want is a plan that effectively manages your estate in accordance with your desires. So you may have desires to how things are managed during your life. during an incapacity and ultimately on distribution where those assets are to go. But also you want to create a plan that is most efficient. And by that, I mean that has the least cost, least troublesome manner when you undergo your ultimate estate plan. There are a number of things that get in our way of both having an effective and efficient estate plan. I've listed some here, 12 or 13 things. We're going to talk about probate today, which is very important, which is a hot topic for estate planning and probably a place to start talking about the subject. But there are a lot of other things that get in the way. They include a whole host of taxes, estate taxes, pension excise taxes, generation skipping, transfer taxes, capital gains, income taxes, gift taxes. There are family problems. There are things you can do in an estate plan to mitigate family problems, whether that be sibling rivalries, whether it be a child or relative or heir that has problem handling money. You can plan for that in your estate. A good estate plan is going to plan for a long-term illness or a long-term incapacity. Clearly, poor investment will diminish the amount of assets you pass on to your estate, as will waste. And then lawsuit. And real quick on lawsuit, I'm not necessarily talking about any sort of asset protection plan here for the moment. I'm talking about those cases where somebody might be in a lawsuit prone business. And sometimes when the matriarch and patriarch pass away, there might be lawsuits that arise. There might be lawsuits amongst heirs. Some child might be in a lawsuit prone business, and you can create an estate plan that protects those assets from creditors of an heir. It might even be a divorce. And there's some things you can do in your estate plan. So I'm going to start in a very sort of strange, perhaps, way, and that is I'm going to talk about initially in this first episode about what happens if we do no estate planning whatsoever. So it's that case where we do not do any estate planning, and I'm going to talk about some of the excuses that people have for not doing estate planning. I'm going to go over that list, and generally what can happen when estates are not planned, and hopefully in doing so, I'll get you to recognize the need for estate planning, even in the smallest of estates. One of the problems with getting someone to do estate planning is just the process. It involves legal services, means hiring an attorney to create planning documents. It's going to cost money. It's going to be a little confusing. The subject matter might be confusing to somebody who is not used to hearing about the vocabulary of estate planning, while the attorney, of course, is quite accustomed to the verbiage of estate planning, and it's going to take a lot of time. So, I just want to go over some of these things and hopefully resolve some of the concerns with a hesitation for estate planning. And I want to talk about some of the things that I've heard over the years that cause people not to go through with their estate plan. And hopefully I can convince you that if you are on the fence about estate planning, that by talking about this unplanned estate, you might want to continue with seeking out an attorney to get a plan done. One of the things I've heard is, if it ain't broke, don't fix it. And that may be a valid concern, or it may mask some other reason why someone doesn't want to be in an estate plan. But the thinking here is that, look, everything's fine. If the client is in their 40s or even 50s and everything's working fine, why bother getting an estate plan? I can hold off until I'm older. I don't want to jinx things while I'm alive. they're fine. The problem with that thinking is that when things are broken, they're really broken, and you will not be able to fix them for this very simple reason that you will be deceased or incapacitated. And no one knows when that's going to happen. You know, when I was a young attorney practicing estate planning law, I would always, every time I got someone into my office, no matter how old they were, whether they were in their 40s or a person age 89, one thing I would say is nobody in this room knows who's going to die first. And we all know that intrinsically. We all know that's possible. Maybe in our own lives, we've seen young people, children die before parents. We've seen young, healthy people die before elderly, not so healthy people. And it's important to know that it is quite possible. And it's important to plan for that because we just don't know what's going to happen in the future. So if it ain't broke, don't fix it. I would argue, be careful, because when it's broke, it's really broke and you will not be able to fix it. A related argument is, I'll get to it, the standard procrastination. I want to do estate planning, but I just don't have the time right now. I will get to it in the future. And I always, that one always worries me because again, no one knows who's going to die first. And we don't know when someone might have either a long-term incapacity or a death. So I would encourage anyone who has decided that they're going to create an estate plan to at least get the process started. Meet with an attorney, get some ideas down, get a basic estate plan. You can always amend it at a later time. You can always make changes, but get something down in writing as soon as possible. Another argument is that I've heard is that I don't really have much of an estate. You know, why bother going through estate planning? And I'm in a moment here, I'm going to go through a small estate exemption. And it is true that small estates in California can escape some of the formalities of passing assets on to heirs. However, I think you might be surprised when you add everything up, especially when it's important that you get a balance of gross value of the estate. In a moment, we're going to talk about the probate process, and the probate process does not subtract indebtedness. So if you own an $800,000 house and you've got a $500,000 mortgage on it, probate is concerned about the $800,000, not the net $300,000 of equity. And we'll see that in a moment. Now, here's the small estate affidavit. And we're very lucky in California. We have a very, very high threshold for what is considered a small estate. Some states are still at the level of, say, $7,000 to $10,000, maybe $12,000. In the state of California, you can have what we call a probate estate of $184,500. That's for deaths after April of 2022, and not go through a formal process. And in fact, your estate can actually be much larger than that, because what are excluded are non-probate assets that have a beneficiary designation. So life insurance with a beneficiary designation, annuities, IRA and 401ks with a legitimate living beneficiary can escape formal probate. Pay on death accounts. When you go into a bank, the bank has the option for you to have a POD designation on the account that says, on my death, pay these assets too. There's a comparable registration in securities accounts called TOD, transfer on death, and you can simply name an heir to that account and have the securities firm transfer those assets to your named beneficiary on your death. Joint tenancy accounts, on death, they go to the named joint tenant, regardless of any estate planning. In California, we have something called community property with right of survivorship, which is very similar to joint tenancy. There's certain tax advantages to the community property. Vehicles typically can escape formal transfer. For one thing, they're normally under the value of 184.5. And also it's almost scary how easy it is in California to transfer title to a vehicle. And then assets held in trust. And I know today we're talking about the UnPlan, but when we start talking about estate plan formally, it is the trust, the basic estate planning tool of a revocable living trust that is designed to scoop up all those assets that are not in a beneficiary designated account, that are in your name alone, and have them managed and held according to your desires. So there's an affidavit process that occurs in a small estate exemption. So let's just say that, again, we're talking about someone with no estate planning. Let's say they have the bulk of their assets in, say, a joint tenancy or a pay on death account. Those escape formal probate procedures, but they have one small account in their name alone. It may be a checking account, and it may have $10,000 to it. The way the small estate affidavit process works here in California is that your heir, let's say it's a child. I die, perhaps my spouse has predeceased me. I have an account in my own name at the bank, and my heir is my child. My child can go into the bank and tell the bank teller, look, my father has passed away. I am the rightful heir to this asset. There is no probate proceeding. It's not necessary because the estate is under the threshold. The bank teller then pulls out an affidavit, hands it to the child, and the child signs under penalty of perjury that they are the rightful heir to that bank account, and the bank simply hands over that $10,000 to the child. Now, you might think that the bank would be a little bit nervous about handing over assets to the child because they might be afraid that a brother might come in next Tuesday and say, hey, my father passed away. I'm the rightful heir to this account. Please hand me the money. I'm willing to sign an affidavit. As it turns out, in the state of California, if somebody signs that affidavit under penalty of perjury, the bank is absolved from any wrongdoing in handing those assets over. And normally the bank has some sense of who the heir is. So the system works quite well in California. And if the second child comes in, essentially the bank, as the law says, the bank is absolved. Go sue your sister. Your sister came in a week ago and took the funds. It's your problem. Now, once the amount is over 184.5, then it is the problem of the bank. They cannot release any amounts over that if the probate estate is over that amount. Just to repeat, the probate estate is generally assets in your own name. Non-probate assets are assets where there's a beneficiary designation to the account. Now, unfortunately, the maximum value for real estate in the state of California is $61,500. So for all intents and purposes, if you own real estate, you will have to get an estate plan because it's the gross value that is important, not the net. So that's a small estate affidavit process. Somewhat related to that is that I've heard this said to me before, that my family knows what I want. They know what I want to do with my estate. I have written instructions to them to do to pass out the estate in accordance with the way I want it. That's all well and good among the family, but unless those documents are formally written that satisfy the state of California as to an estate plan, a meeting of the minds among the family is not going to do any good. Think back about this walking into a teller and there's a $200,000 account in your own name, and your child goes up to the teller and says, hey, my dad wants me to have this. He said so. He wrote this a memo, and unless that memo qualifies as a a formal will or trust, it's not going to be any good. The fact that it's over $200,000 in the parent's own name means that the bank teller is going to say, I'm sorry, but you may know what you want. You may know what your father wanted, and your father actually did perhaps want this, but we don't know that. And the state of California doesn't know that. So the teller is going to ask you to go to the probate court and come back with a court order declaring that you are the rightful owner of that $200,000 bank account. So unfortunately, an agreement amongst family members is just not valid unless it's formalized. And if the amount is larger than 184.5, there's going to have to be a formal probate process to do that. So not only is there a formal process for handling an estate, but there's also, when you do not do any planning at all, when you have no estate planning whatsoever, and there are assets that fall into this probate estate category, the state of California has a plan for you. That plan that they've written, called intestate succession, may or may not be what your desires are for your estate. Another one I hear quite regularly from not doing estate planning is, I have assets in joint tenants. And sure enough, as I mentioned earlier, joint tenancy property is excluded from that probate estate. So as long as we have a joint tenant, as long as husband and wife are joint tenants of property, husband dies, everything will go to the joint tenancy surviving spouse. But there's a lot of problems with joint tenancy. And I want to go through those because it's very important to know. Joint tenancy may seem to be a magic bullet for not doing proper estate planning. And let's take a look. Joint tenancy typically works once. Husband and wife have assets in joint tenants. Husband dies. Now where are the assets? They're in the wife's name alone. So what does that do? Now the wife has to find a joint tenant. Maybe the wife doesn't get to putting assets in joint tenants or creating an estate plan. Maybe the wife is incapacitated. So there's a real problem when a surviving spouse is unable to handle affairs, even assets that are held in joint tenancy. So the bottom line, it works once, and it relies on the surviving joint tenant to quickly get assets in a form that will avoid the probate process. There are some tax problems with joint tenancy. We're going to get to those at a later time. It has to do with basis adjustment at death. And I'll just leave it at that because it is a tax issue that I'm going to bring an accountant on to talk about that. Joint tenancy can be problematic upon incapacity. So we all think estate planning is all about what happens when I die, but we mentioned earlier that there can be something worse than that, and that is a long-term incapacity. So if I have my assets in joint tenancy, and I have a long-term incapacity, which means I cannot sign documents, I can't open accounts, I can't close accounts, I can't sell real estate because I can't sign escrow instructions. There's a real problem if assets are in joint tenancy. So, and that gets back to that planning for incapacity. Joint tenancy does not do the job very well. Joint tenancy doesn't plan for contingencies. It doesn't plan for what happens if a child dies before a parent, and what happens if there's a long-term incapacity. What happens if somebody that you want to be your heir dies or becomes incapacitated? It just doesn't handle that. So you need more than just joint tenancy to make sure you have an effective and efficient estate plan. So now I want to talk about, we talked about the problems that get in our way of estate planning. We had the whole list. The first one and the big one is probate. Probate is as I mentioned here on the slide, is the court supervised process for handling your estate when you are unable to do so by reason of death or incapacity. Probate involves a lot of time. It involves attorneys. It involves courts. It involves judges, delays. It is not really a very effective or necessarily efficient way of doing an estate plan. It is expensive and probably more expensive than doing things privately with an estate plan, certainly a trust. It is just reading, this is right out of the probate code section. It's 4% of the first $100,000, 3% of the next 100,000, 2% of the next 800,000, and 1% of the next 9 million, and so on. And all of this is without regard to encumbrances, as you see there, I've highlighted. So when we talk about the probate fee schedule, the fees apply to the gross value of the estate. Earlier, I used the example of the $800,000 house with a $500,000 mortgage. What you really own is only the $300,000 of equity, but probate fees apply to the gross value of the estate on the theory that it is the $800,000 house that is being managed in the probate process. So we're going to apply these fees on the gross value. In addition to these fees, the attorney can charge extraordinary fees. And that can be when the attorney does some work over and above what the normal fee schedule is designed to, and they'll apply for those. They'll apply to the judge for extraordinary fees. And the judge either approves them or denies them. And here's the kicker. There's two fees. So the attorney gets this fee, and then the personal representative of the estate gets the fee. And the personal representative can be an executor or what we call a personal representative when there's no estate planning at all. So here's an example of a $5 million estate. And let's think about a $5 million estate. That may sound like a lot, but it can be a house, it can be a bank, it can be an investment account, it can be a business. You can get there pretty quick, but even smaller estates, the fees are quite large. So as we saw before, it's 4% of the first $100,000 or $4,000. 3% of the next $100,000. So we're already at $7,000 just for the first $200,000 of estate. 2% of the next 800,000. So the first million is $23,000 here. And 1% of the next 4 million or 40,000. So that's a total of $63,000 for the attorney to take your assets through the probate process and get those assets to the point where they can be transferred to an heir. And that usually means a court order. And note that the executor or personal representative also gets the same $63,000. So it's $126,000 to transfer this $5 million estate onto heirs. And that's exclusive of the extraordinary fees that the attorney might charge. So again, it's very expensive, but there's other reasons why you may not want to go through probate other than just the fees, although the fees are certainly something to be concerned about. And I do get clients to say, I just don't want to deal with attorneys. It could be that there's been bad experiences. It could be that somebody's gone through litigation. It could be that they've gone through a divorce and they've had a bad experience with attorneys. I will tell you that sometimes attorneys are necessary, especially in estate planning. And I will recommend the right attorney, but I will try to find the right attorney that I know the client is going to use, because the worst case scenario is just somebody doesn't do estate planning whatsoever. Sometimes I get clients, and I've had this very rarely, but I've had it, that say, I just don't care. And again, sadly, I think it's those clients that think of estate planning for what happens when they die. And I've had clients say, look, when I die, whatever it costs, whatever trouble it is, it's not my problem. I'm going to be deceased. It's not going to bother me. It's all done for my heirs. And sometimes the client maybe even doesn't have close heirs. It may be distant nieces and nephews, and they just really don't want to go through the expense to benefit a future heir. I do want to caution these people in the I don't care category about the problems of incapacity. So it's not necessarily true that it's all estate planning is for the benefit of heirs. It can be for the benefit of yourself when there's a long-term incapacity. So again, just to repeat about incapacity, it's a time when you can't write your own name, you can't legally sign. So managing your investments, managing your business, getting a loan, selling property, you need estate planning documents to plan for this possibility that you will be unable to do so, but very much alive. So in that I don't care category, I emphasize, be careful. You may very well care when it has to do with your own personal well-being and handling of your estates while you're alive. So there's the reason some people might want to do no planning whatsoever. They've heard about joint tenancy. They've heard about the small estate affidavit. So just a real quick review. What did we talk about? We started this estate planning 101 course with an idea of what estate planning is all about. It's about managing your affairs. And here today, I'm talking about financial affairs, putting your assets in a form that can be handled for you, live, die, or become incapacitated. We talked about the probate process and what a probate estate is. It's basically assets in your name alone that can be a problem when it comes to death or incapacity. And finally, we talked about some of the excuses and some of the reasons we might think about maybe handling, maybe going through the process of handling our estate in a formal estate planning process, which we're going to talk about. So I want to thank you very much for listening to this brief introduction to estate planning. The UnPlan may not be the best plan for you. And we're going to talk about that in my next episode, where I'm going to invite an estate planning attorney onto the show to talk about what he does for estate planning. Thank you. And we look forward to talking to you next time on Radio Pete's Wealth Talk.